Van Turnhout and Senator McAneill, and it arises out of committee proceedings. Amendments 1 to 11 are related. Amendment 2 is an alternative to 1. Amendments 4 to 11 form a composite proposal. 4 to 11 inclusive are alternatives to Amendment 3. Amendment 1 to 11 may be discussed together by agreement if that's agreed. Is that agreed? Agreed. Senator Van Turnhout.
Thank you very much, and very welcome to the House, Minister. And I would like to note firstly with appreciation that at committee stage 2 important amendments that I raised at second stage and tabled amendments at committee stage have been incorporated into this current bill by government, and I thank you for that. I think it's very important that we now have clarity about the application of the legislation with respect to multiple convictions arising out of one incident or offence. I strongly welcome the extension from 12 months to 2 years of the maximum applicable sentence for a relevant non-custodial sentence. I hope at a future review of the legislation that this limit will be extended further to allow a greater number of people to avail of the clean slate second chance that legislation aims to provide. I'd also like to thank the Library and Research Service for an excellent Bills Digest and for conducting additional research at my request, which I'll be sharing with you shortly. I also thank IPRT for providing background information in the case studies, which I think have helped us all, and certainly me, to strengthen my resolve in calling for a liberal and generous spent convictions legislation as possible that we can have. For me, this is not about being soft on crime or unduly lenient on offenders. It's about showing foresight and an appreciation of the long-term holistic benefits of encouraging the rehabilitation and reintegration of ex-offenders back into society. Minister, you will be aware since my initial statement at second stage that I had hoped that the bill would go further. I've tabled a suite of amendments which would see the maximum applicable sentence for a relevant custodial sentence extended from 12 months to 2 years. I've proposed 2 years as a compromise between the 12 months in the bill and the 48 months applied under the UK legislation, and now being also proposed by my colleagues in Sinn Féin. I've listened carefully to the government's rationale for holding fast on the 12-month exclusion point, and indeed I do want to welcome that it exceeds by the 6 months which was recommended by the Law Reform Commission back in 2007. Nevertheless, I maintain that 12 months does not go far enough, and I'll address some of the points that were raised during committee stage in this regard. Firstly, the government has pointed out that the UK legislation represents the most liberal spent conviction schemes in the common law world, and that in comparison to Australia and New Zealand, what has been proposed in this bill is liberal. Minister, this is indeed true, but it's also true that the UK has had a 40-year head start on Ireland with spent convictions legislation. During this time, the UK Ministry of Justice has strived to strike the appropriate balance between public safety and reducing barriers to reintegration for those who have moved on from offending behaviour. As you know, the Ministry of Justice commissioned a review of the Rehabilitation of Offenders Act, and it was called Breaking the Cycle: Effective Punishment, Rehabilitation and Sentencing of Offenders. And this report recommended that the limitation of the spent conviction scheme to 30-month sentences was too restrictive. And in response, the UK Government, through the Legal Aid Sentencing and Punishment of Offenders Act 2012, has reformed the relevant sections of the Rehabilitation of Offenders Act, setting the limit at 48 months, 4 years, which is 4 times the limit proposed in this bill. I appreciate that the schemes in Australia and New Zealand are, on the flip side, more restrictive, but I don't see any convincing argument to align ourselves with their position. We need to look at the purpose of the bill, which is clearly set out in the memorandum. It says to assist the rehabilitation of offenders who often experience difficulty securing employment as a result of having a conviction, and thinking how we can best achieve this aim. And the key question is, what is the maximum sentence for which an ex-offender should be able to avail of a second chance legislation? Surely the more people who fall under the remit of the legislation, the greater the positive impact on ex-offenders and society at large. Which leads me to my second point, which concerns the suggestion that the 12-month cut-off point covers almost 90% of all custodial sentences handed down by Irish courts. And Minister, in light of this figure, I sought information about the number of people who have been convicted of sentences of up to 2 years. There is no data actually currently available on how many people in the population have convictions of not more than 12 months but less than 24 months. So between that 1 and 2 year figure, I tried to see what are we actually talking about. The Court Services records all sentences of imprisonment up to 2 years together and then breaks them down for the information based on the type of offence like assault or theft. The data does not distinguish between sentences of up to 12 months and up to 24 months. Figures from the Irish Prison Service provide a partial picture of the amount of people who have custodial sentences that may come within the scope of the bill. However, these figures only look at those serving prison sentences. They are limited in their application, as by definition they exclude those who have received suspended sentences and other sanctions such as community services orders, fines and probation orders. Taking out the sentences that cannot be spent because of their seriousness, such as sexual offences and homicide, and bearing in mind that the data is based on the number of committals, not the number of people or sentences, and so if people are released and recommitted to prison in a given year, they will be counted each time they are committed. 87.2% of all of the prison population in 2011 would be eligible to have their convictions spent as they are serving sentences of less than 12 months. A further 4.83% of prisoners could benefit from a spent convictions regime if the sentence of up to 2 years was eligible to be spent. And that would bring the overall percentage of convictions covered by the spent convictions legislation to 92%. So in a way, Minister, I'm asking you to move a further 2% in this legislation, because you've said that this will cover 90%, and if we were to go for the 2 years, it would move it to 92%. And I think it is very interesting, Minister, that the court services do not record the difference between the 1 year and the 2 year, which for me very much sends a strong signal that they are considering them to be grouped in offences. And for me it strengthens my argument in seeking for it to be extended to 2 years. I believe such an extension is in keeping with the spirit and purpose of the bill and would have a significant and positive impact on the life and future of ex-offenders convicted of sentences of 2 years and under, and it would also have a positive impact on their families. In moving to the schedule, Minister, that I propose, the overall rationale to this part of my amendment is that the currently proposed rehabilitative periods of 4 to 5 years and 2 to 4 years respectively for relevant custodial and non-custodial sentences are much welcomed improvements on the periods proposed in the bill as initiated. And I don't intend to push this amendment to a vote, Minister. I do feel strongly that in order to achieve the objective of the bill as set out in the accompanying explanatory memorandum, the bill needs to be as generous as it possibly can be. I have wondered if, in taking the more conservative approach, has the government been afraid of accusations of undue leniency and being soft on crime. And I can understand the concern, giving public concern over crime, the fear of crime, the fear that it has on impacting on people's quality of life. But I see this legislation, which encourages rehabilitation and reintegration as former offenders, as a tool which must be implemented with a raft of other interventions such as rehabilitation, treatment and reintegration measures. But I see it as a tool to make society a safer and fairer society for us all. A less restrictive spent convictions regime, negating as far as possible against the negative, far-reaching and oftentimes discriminatory consequences for ex-offenders and their families, would also, I believe, reflect the qualities in an Irish society of compassion and forgiveness. Minister, I'm aware of research conducted by the UK Home Office into reconviction rates, which suggests that if an individual has not reoffended in the first 2 years post-conviction, they are at equal risk of further future offending as someone with a previous conviction. And this finding is in keeping with the fact that in UK legislation, the conviction-free or rehabilitative period at the lowest end of the offending scale is 2 years. The length of time required for rehabilitation must be proportionate to the seriousness of the offence committed, but it should not be so long as to constitute an additional and disproportionate punishment. And I think, Minister, it's been very clear, both at this stage, but at a committee stage and second stage, how we all in this House welcome this legislation and very much support this legislation. And in the amendments that I'm putting forward, I just feel we can go that little bit further to give more people an opportunity to go for that pathway of rehabilitation, of having a second chance, a new start in life. And that is why I would urge you to reconsider looking from the 1 to 2 years. As I said, if I look at the figures, and I've gone through them very carefully, Minister, it's 92% would be covered then by the legislation if we moved it from 1 to 2 years. And I'd ask you to give it strong consideration. Thank you.
Gur mí mar les hair lípas ché fáilú agus go generalta tamuide bháfar an bhilise go háid agus tamuide teach chud is mó leis an seanad of an turnout leis méidir tá chu chun cín ach go bhfuil muide cainte cearcha 8,000 seachas 2,000. We're recommending, I suppose, very much in line with that Senator Van Turnout is